Next case is Hicks versus Schmidt, case number 2021G-005. Matter coming on for a preliminary review. I need to recuse myself from the matter because of the conflict. Go ahead and pass the gavel to the vice chair. I'm going to step out until this matter is completed. I ask the record reflect that I have recused myself and I'm not for hearing you.
You've just done that.
Okay. All right, in this matter, Hicks versus Smith, 2021G-005.
Mr. Chair, do you want me to go about and lay out the basic outline?
Yes, please.
I will
Okay.
do so. The complaint asserts that the respondent essentially did not provide complete information that certain campaign finance reports, accepted direct corporate activity in her campaign finances. The respondent submitted a motion to dismiss, so the complainant did not invoke the proper personal knowledge. In addition, additional materials were filed in the last couple of days, really from both parties, making additional statements as it relates to why the reports were complete when originally filed, or when subsequently filed, and additional comments in an amended affidavit submitted by the complainant. All those materials have been circulated to all of you. Based on the materials that have been presented, my recommendation is to find a violation. You can certainly hear from Mr. Hicks, who is here, who is the complainant, and Mr. O'Brien is here representing Ms. Schmidt, if the chair so chooses.
Phil, did you mention there's a motion to dismiss also pending in this?
Yes, I said the respondent submitted a motion to dismiss based on the complainant's failure to invoke personal knowledge appropriately.
Do the commissioners have any questions on the recommendation of the executive director?
Well, I guess I would ask Phil, what you relied on to come up with your recommendation of no violation?
Well, the complaint essentially primarily gets down to whether certain information was included in campaign finance reports. The submissions all provided that either in the first primary report and or subsequent reports that materials were provided to the Secretary of State's office that would reflect complete filings, and that those reports have been accepted by the Secretary of State's office. So that's the primary basis for my recommendation, based on the materials that we have had provided to us. I'm obligated to make a recommendation based on the materials that are provided as a part of the original complaint process.
But why aren't you mentioning the emails that were provided that shows where the resources are being paid for? So you're selectively talking about materials.
You can't have you testifying until you're sworn in, and I've been on the commission now coming up 5 years, and historically, we've heard from both complainants and, in this case, counsel for the respondent. So if we're going to do that, let's just have them, obviously Mr. Bryan doesn't need to be sworn in, but we need to swear in Mr. Hickson. If they have something they need to add in addition to what's been submitted, I say we do that.
Okay, I would say that we do that.
I think that's fair.
Well, let me ask, before we do that, I heard Mr. Richter give his explanation as to why he recommends no violation be found. So, in all the filings made against Mr. Hicks's position, most, I think, are centered on personal knowledge. Did that enter into your deliberation or into your mindset as to your recommendation, no violation?
No, it did not. I mean, certainly that is, we could hear from Mr. O'Brien if you wanted to hear from him further beyond what is included in the original submission. The general approach that I take toward a complaint is, does it include what I've always looked at is essentially the 5 basic elements: complainant, respondent, proper addresses, a written statement of the case, an original signature, and a proper notarization. If those things are there, then I put it before the commission. And then, certainly as the commission looks at the materials, and as in this particular case, as Mr. O'Brien has done, if the party wishes to make an argument that there isn't sufficient personal knowledge reflected in the materials that we have, the commission can take that into consideration. I would as well. Considering all of the materials that were included in the complaint, while certainly I would agree that Mr. Hicks never used the words personal knowledge in the complaint, considering what's contained in the complaint in terms of the review of all the materials provided, etc., to me that's sufficient in order for the commission to proceed forward on matters such as this. And so I did not take the motion to dismiss into consideration as I made my recommendation.
Okay. Thank you.
And that's kind of the standard that I operate under as I'm going through this process.
Okay, so we want to hear from Attorney O'Brien.
We can certainly do so. Mr. O'Brien, if you come up and be on the respondent side, Mr. Hicks, if you come up and be on the complainant side. Did you want to address the motion to dismiss first? Do that, or hear from Mr. Hicks as it relates to the nature of his original submission?
You know what, I think that we should hear on the motion to dismiss that one.
Okay. Mr. O'Brien?
Thank you, Mr. Richter, Mr. Vice Chairman Beatty, other members of the commission. Appreciate the opportunity to say a few words regarding this preliminary review, which at least has 3 separate allegations in the affidavit that was filed. They deal with failing to report a contribution, which is alleged to have been an in-kind contribution by the Ohio Republican Party, failed to properly report expenditures, and then thirdly, accepting an illegal corporate contribution. I'd ask the commission to consider each of those separately, and in reviewing the complaint, it struck me that having observed affidavits, whether they're in a criminal case or whether they're in a motion for summary judgment, they start off with based upon personal knowledge and belief. The affidavit here did not do that, and throughout, as the complainant listed the facts that he supposedly relied on, the facts were unconnected, disjointed. They were 2 emails suggesting attendance at a meeting in Claremont County, and another suggesting that this person had been added to a Facebook account. That was it. And Mr. Hicks makes bold-faced assertions, conclusory allegations. Well, these folks worked on the Schmidt campaign. No basis. I didn't see him go door to door. I didn't see him hang signs. I didn't see him attend a meeting. None of that is in there. They're just bold-faced, conclusory allegations that I think when the commission and Mr. Richter review, I think you can easily conclude that he has no underlying facts he's presented to the commission regarding that. He's attached a pay stub from Ohio Republican Party for one of the parties involved. However, that's for a time frame of March 8th to March 21. And the email he attaches is dated February 11th. I mean, how is that connected? And even if Mr. Mancini was on the payroll, there's no indication that he was on the payroll for purposes of helping Ms. Schmidt. In fact, just the opposite. I went the additional step in an addendum that was filed that has an affidavit from the executive director, the former executive director of the Ohio Republican Party, Rob Seekauer, who says flatly, without hesitation, that Gene Schmidt's campaign, that Mr. Mancini had not been directed, not been paid for any work in connection with that campaign. And so we have first no direct evidence from Mr. Hicks, but secondly, we have the ORP saying we didn't pay him, and certainly if Representative Schmidt had received from ORP notice of an in-kind contribution by that employment, that would have been included on the report. Prior to the general election, her report, her pre-general, does reflect, and it's attached to the supplement that was filed on Monday. She reported an in-kind contribution from the Ohio Republican Party. She and her treasurer know how to report that, and when they get notice, they do report that. And at least as you all well know, this is not a strict liability offense. If Jean Schmidt has someone who does work on her campaign, doing anything, and she has to know that they're being paid before she would report that as an in-kind contribution. And having been candidate myself 10 different times over the last 50 years, you receive a notice from the entity that's doing the payment, and you include it on the report. And so the complaint on its face is insufficient and doesn't confer jurisdiction on the commission. And then I think secondly, when we look at the evidence that was submitted, or the sworn statement, it doesn't establish a violation. Secondly, what the argument and allegation is that a corporation was engaged, and because, apparently, the only argument could be made, because they were not paid upfront in advance for their services, that somehow was an illegal corporate contribution. The filings that are attached in my supplement that was previously filed reflect that Ms. Schmidt's treasurer properly filed a report that listed an invoice for services. That invoice was for $164,000. That report that she filed reflects $100,000 payment and an outstanding balance of $64,000. So a vendor, and that's who it was, a vendor did work for the campaign, submitted an invoice for $164,000. She paid $100,000 of that, had an outstanding balance of $64,000. The very next report she filed, and that's also attached, reflects she paid that $64,000 in the interim, and she owed that vendor $0. And that's not an illegal corporate contribution. It's a vendor who does serious services, who happens to be a corporation, who is partially paid. That's reflected in the report. And then in the subsequent report, that also is accurately reported and reflected. So either on any of the three allegations that are in this complaint, I submit the commission should follow Mr. Richter's recommendation and dismiss it, because there's no personal knowledge, there is no probable cause of a violation of Ohio election law. And unless the commission has any questions, which I'm happy to answer, I will conclude my remarks.
Before we turn to the opposing party, does anyone have any questions for Mr. Brown?
I just wanted to, for the record, I don't believe, sir, that Mr. Richter said his recommendation to find no violation was predicated on personal knowledge. That wasn't an issue.
That's what you did say.
Yes.
Yeah.
Okay.
All right. Seeing no questions, Mr.
Okay, thank you.
Yeah.
Yeah.
You need to swear me in.
Please swear and affirm that the testimony you'll be able to give is the whole truth and nothing but
I do. Okay. So there's three. First off, I appreciate the discussion of personal knowledge. As a citizen, not an attorney, I think it's ridiculous that you have these attorneys that constantly have this personal knowledge thing, which would say that an investigation done by a citizen, for example, getting records and so forth, and examining them and reviewing them would not be personal knowledge. So I think your personal knowledge thing would be good for you guys to have an opinion on this, because it's nonsense. I think what it's more intended for, should be intended for, is things where you have maybe a straw filer, where a political opponent gets somebody to file something for them, to get to where they don't want to have their name on it. and that would be wrong, but I can assure you, anything I ever file here, now or in the future, is based on my knowledge, my research, my hard work. Okay, and I resent the constant implication by these attorneys that it's not.
It's not a connotation, it's just a matter of law. When you file an affidavit.
May I finish, can I continue my remarks? Okay, without interruption, please.
You're not gonna tell me what to do, Mr. Hicks.
Okay.
And an
Go
affidavit
ahead.
is supposed to be based upon your personal knowledge, and you're supposed to swear and attest that it's your personal knowledge. And if you didn't do that, then that's on you, that's not on us.
Okay. Again, I love the warm reception here as a citizen. So there were three things alleged in my affidavit. One was that JPL and Constant Content staff were working with Gene Schmidt, Stephen Caraway, Tommy Rolfe, Anna Lippencourt, Megan Fitzmartin. Okay, those were never reported anywhere. They were not reported even on her filings of the $164,000 related to Constant Content. Those filings specifically said that they were for media, airtime, and mailings. I personally know, because I've interacted personally with Stephen Caraway, that he was being paid by Constant Content under Churn Creek Consulting and was working with the Schmidt campaign and the Freeman campaign, as were other people. That has nothing to do with the ORP. Also, the resources were being directed by, not the ORP, but by people from JPL. So that ORP staff was almost entirely directed by, and you can, I have exhibits here, but there's exhibits in the other case, almost entirely directed by Tommy Rolfe, telling them what to do, where to go. So Mr. O'Brien said at one point, he said, all I had was an email showing that he was being directed to attend meetings for Ms. Schmidt, and all I had was an email saying that he was being given rights to administer and moderate her Facebook page. Absolutely right. That's two of the things I put in there. That proves what I'm saying. So the point of I look because of his last minute filing. So Mr. O'Brien filed the affidavit from Rob Secor, which I think makes more questions, not less, around this matter. Doesn't resolve anything. It just says we weren't the one directing Mancini as to what he was doing. That caused me to go look. I didn't have time to respond to it because it was only submitted Tuesday at 5. So I haven't even had a chance to investigate the law or understand what's being asserted within that in his last filing. But it caused me to go look at your rules and find the section, alternatively, as the commission does not believe there is at least a possibility that a violation of the statute has occurred, but is not convinced that that's the case, the OEC could then decide to set a matter for a full and complete hearing. So do we think there's at least a possibility? Well, let me talk about two of the other things, because I mentioned the Constant Content and JPL resources. We talked a little bit about the ORP staff. Let's talk about in my amended complaint, where I got more information from the Secretary of State, of the notion that this campaign, the Gene Schmidt campaign, was advanced $164,000 for paying for media and airtime. The staffing's over here, it's not accounted for anywhere, the staffing, okay? For media and airtime that she didn't have in a race that she won by 318 votes and then paid back later. Now, I don't have evidence to support what I'm going to say right now, but I think part of the reason that it even got declared is because I put so much heat on the system in Claremont County about financial reporting in campaigns. So contrary to the director's recommendation, I believe that this should have a full hearing. And he made a lot of misrepresentations. He failed to mention the email. Mr. O'Brien, you mentioned that I had a pay stub in there for somewhere in March. But I also had the ORP reporting in the system that showed a pay for February 21st. So Mancini wasn't just being, if you look at mine, it's exhibit number in mine. I don't just have a pay stub, I have the actual ORP reporting in the campaign finance system that shows all the pay stubs, which is, it's exhibit number 1. On 2/21, he was paid $2,286.33. So he failed to mention that. He made it sound like, well, it was a different time period. He put in his filing stuff relating to the general election. To the general election, when she was then being supported by the ORP in the general election. That has nothing to do with the primary. It has nothing to do with this constant content money. So I think in my affidavit, I think these cases are sort of the canary in the coal mine on this household stuff. Because we know, if we're honest people, that, you know, something fishy's going on in terms of this money getting fronted through Jeff Longstreth's campaigns into these candidate accounts to a massive amount of staffing being provided that was never accounted for anywhere. So the notion that there's not at least the appearance, at least a possibility that a violation of the statute has occurred, it to me is absolutely ludicrous. The 2 emails are enough, and he puts things in his filings. I'm not even a lawyer. He puts things in his filings about probable cause. That's not your standard. That's not the standard here. So again, we have got to fix the integrity of campaign finance in Ohio. This is the board. You are the people. And I've provided more than sufficient evidence that there's at least a possibility that a violation occurred. Might I remind you that if she was fronted $164,000 from a non-lending institution, that's illegal. Okay? I know there's some rules like your family member, stuff like that, but if just some out of the blue person gives you, fronts you a lot of money, that's not proper. So again, I think that what we find with the Freeman thing and what we find here is that I think I've provided more than enough information that there's a possibility of a violation occurring. I think you talk about helping me sometimes with being able to get discovery on things. I think discovery would open another can of worms here. This matter, it really came out of the discovery related to the Freeman matter. I don't know if you guys understand, but Claremont County was the epicenter of Larry Householder stuff, of constant content money flowing around. There were literally, for 2 House races, if you look at the money, what we'll talk about later and the other things, but something on the order of $500,000 to $600,000 fronted to campaigns through Jeff Longstreth to both the Freeman and Schmidt campaign. And I can, later we'll talk about where those numbers come from and how you can add them up. Because they're coming from documents, they're not just coming from thin air, they're coming from documents. That's in addition to growth and opportunity tax money that was spent in Claremont County, which I don't know that number. People speculate that it's at least the same number. $1 million. $1 million of money getting spent on 2 House races. There is absolutely at least a possibility that violation of statutes occurred. But I would say also to dismiss such a thing today, when he filed stuff into the case Tuesday at, I wrote down the exact time, Tuesday at 5:10 p.m. is when this new affidavit appeared, without me having any sufficient time to respond to it. So I think either this needs to be, I think it should be set for a full hearing, or it should be continued, because also, as I brought up to the director, 2020 G019, the Freeman case, that one is going to reveal more stuff that intertwines with this case. To dismiss this case now, when there's another case that involves the people that bought media and so forth together in concert, would be, I think, not in the interest of the citizens of Ohio, and not in the interest of campaign finance integrity in our state that we so desperately need. So thank you very much. Is there any questions for me?
Hearing no, any questions? Hearing no questions, we'll have a response from
I could give a lengthy response, Vice Chair Beatty, but I'd like to hit 2 things quickly. I don't know where Mr. Hicks is reading these things from, but because of his past history of doing that, I brought your rule 3517-1-11, preliminary review and hearing, subsection A specifically says that the commission will determine jurisdiction, sufficiency of the complaint, and whether a probable cause exists. And I think quite clearly that is a standard that the commission should use, and by rule says it will use in deciding whether or not this goes forward to another hearing. And what Mr. Hicks wants to do is to have this set for a hearing so he can start taking depositions, so he can start sending out discovery requests. And that has been, by my observation in the other case that he referred to, what he thinks he's a one-man Claremont County grand jury looking for everything that happens in the state of Ohio that he disagrees with, and is using this commission for that purpose. And I just think that the commission should not allow itself to be used for that purpose. The allegations, he stands up here and says many things, but none of them are in his affidavit, his sworn statement, which is not on personal knowledge. So at least I would ask the commission to find that the complaint is insufficient on its face and to dismiss. And thank you for your attention.
Okay. Before we comment and handle the motion, will Commissioner Norman or Cunningham, just for the sake of the commission,
We're getting called out. We're looking at each other like.
Thursday, going home to get the water, but would you, for the sake of everyone, speak to the standard for a motion to dismiss? What the standard is that we have to reach for the motion to dismiss?
Go ahead, Commissioner Cunningham.
In a motion to dismiss, you have to present the facts presented in the complaint, in the civil rules. You would have to present the facts in the complaint are true, and that there isn't any additional evidence that it has to be considered. It's based on the complaint alone, and if you determine, based on the complaint alone, that it doesn't sufficiently address a cause of action before the court under which under any theory there could be recovery or reward or
You look at the
success on the merits, then it must be dismissed.
evidence in all white in their favor.
Everything in their favor.
Same as the rulings of motion for summary judgment.
But there's no additional evidence considered. It's strictly based on the face of the complaint itself.
And based upon the complaint, there's no set of facts that we can determine that they're entitled to recover.
That they could prevail.
Correct.
Now, preliminary review's a little bit different, I think, and I did actually find that administrative. And Mr. O'Brien correctly states that that really is a little bit different than a motion to dismiss because it allows you to consider both sides. Says a commission to consider both sides, both what was originally filed and any responses and affidavits that were filed, we consider it all. So it is more of a probable cause hearing rather than a motion to dismiss standard. So for me, I don't know if it's a lower standard, but it's a standard that considers broadly more things. Because we can consider the response and we can consider all of that. We can, when we hear it as a full panel, we would consider both sides, we would weigh that and make a determination whether we believe that probable cause exists, that they could prove a set fact of circumstances in a full hearing. I don't think, at least I don't find the standard that Mr. Hicks is talking about. Our standard is whether we as a commission determine that there are material facts in dispute or enough information that we believe it should be sent over to a full hearing before the commission. It's not the criminal law standard, I don't think, that Mr. Bryan would be used to. It's a civil standard, so it's a little bit lower than that, but it's still, you're still looking at it to determine whether or not you could find, with more evidence, you could find that there was a violation. Usually we have that as a pretty high standard. I mean, we don't, it's not there might be some possibility that they could prevail. It's usually a little bit stronger than that, but I look to Mr. Richter maybe to fill that in for us.
No, I think that's fair. And that's part of the reason why my recommendation was not based on the motion to dismiss, was because I believe that there was sufficient, even though it wasn't stated, there was sufficient personal activity, even if you want to know what's in personal knowledge, that you could impugn into all the materials submitted, but in taking all the materials presented, complaint, response, etc., that would go to that level. And yeah, I think what we're looking at here too is, if similar to the first case was one where we had sufficient evidence to fully determine all of the facts of the case and say there was no violation when we dismiss it. Here, in looking at again, my recommendation is based on because I'm obligated to give a recommendation based on the complaint, the responses, excuse me, and make that recommendation. If there is a belief that there is a sufficient probable cause, then we should set the matter for a full hearing. I don't believe that there's a sufficient showing in the complaint of a violation at this point. But again, I'm comfortable with my recommendation to find no violation based on all the material, all the written material. We certainly heard comments. Commission members could be impacted by those comments. I wasn't necessarily. you know, so I mean, that's kind of where I'm coming from, but, you know, you're right in terms of, I believe, you know more than I have, a motion to dismiss, as opposed to assessing all of the documentary materials and comments that have been presented to the commission today, and then proceeding from there.
I have a question, Mr. Ricker. I heard the words come out of Mr. Hicks' mouth, which was maybe a continuance of the preliminary hearing because he just received the affidavit on Tuesday evening. I'm all in favor of due process. Does that affect your opinion at all?
No.
Okay.
I'm, from doing this for a long time, I'm used to receiving various materials at various times. You know, maybe I should take more time, et cetera, but, you know, anytime we're leading up to having an assessment like we do today, you know, I'm used to getting materials at the last minute. I got responses in some of the preliminary, or the group recommendation cases over the last couple of days, that, you know, I included my recommendations to you guys.
As a procedural matter, you recommended no violation, but there's a motion to dismiss. Would it be a recommendation of a motion to dismiss or a motion to find no violation?
Mine is a recommendation to find no violation. If I were asked about the motion to dismiss, I would deny the motion to dismiss and finding no violation.
All right, here's what I think that we should do. Let's hold the motion to dismiss at abeyance, and let's see if there is a motion to accept the executive director's recommendation of no violation. Is there a motion?
So moved.
Is there a second?
I'll second it.
Any additional questions before we call for the vote?
You want discussion on it?
Yes, discussion or questions, yes.
From my perspective, I would say that it's not really a fine line for me. I understand that, you know, I think that with pro se applicants, we tend to give them, at least I tend to give them a little bit more slack than lawyers, courts tend to. They're still, though, held to the same standard under the law as if, you know, when you choose to be pro se, you don't get a relaxed standard for everything. You get a little bit of leeway, just in terms of approach. And I think that was part of Phil's comment about the affidavit and whether or not it's sufficiently established technically personal knowledge. Lawyers might look at that a little more technically, as Mr. O'Brien is, and I think Mr. Toronto alluded. I think Phil gave him the benefit of the doubt to say, yes, you know, that we're going to accept the affidavit on its face as adequate, and his recommendation has that in it. But I think, you know, just saying that because I investigated and I, you know, you still have to have actual personal knowledge. You can't just tag together hearsay and unsubstantiated allegations. There could have been affidavits, you know, of these people that I was working for this, or I received money for this. There are allegations that they did, but certainly they were paid. They were employed by someone and paid by them. But you know, I have to agree with Mr. O'Brien when he's saying there are a lot of allegations here, but the dots aren't connected. There's not established a direct relationship, and the filing of a complaint without some kind of a tie together, to me, is problematic. We have documented public evidence about what was filed and invoices and those kinds of things accurately reported. We have no information that there was knowledge of an in-kind contribution. So I'm troubled by all of that. So for me, it did not rise to the level of establishing enough of a probable cause for us to set for full hearing. I don't know that that would be res judicata if they could actually establish a complaint that had that. When you were saying that in a preliminary review there is no violation, I looked at Phil on that issue because I never researched it. But that, for me, that's part of it, is you got to do more than just do some research and make some allegations about people to show a direct connection and some information from them or someone or somewhere that's reliable, not just hearsay that it's connected.
For those who are not lawyers, res judicata says this is the law of the case. And if you have the information, you need to bring it here. And if you can't prove it here, then you can never bring it again in the future. And so it's basically saying you can't get 2 bites of the apple. And so if he had the information, if he had the evidence, if he had the testimony or affidavits to support it, he needed to bring it here. And if we go forward and find no violation, he doesn't get the opportunity to bring it again.
I assume, is that right, Phil? Are we res judicata on
I-
the preliminary
I-
review? I don't know.
I don't either. I've researched this on the civil side of cases, and it's called the law of the case. It's basically wrapped in with res judicata, but it says you don't get 2 bites.
Yeah, but it's preliminary review is kind of different than merits
It may be.
filings.
And I haven't looked at the administrative code from that standpoint.
Great, probably Phil hasn't either, because he's looking at the
Yeah, I was gonna
code.
say, yeah, I'm trying to
I don't
think
know
of-
the answer.
Yeah, I mean, we haven't really had that specifically argued before. So we have had certain cases, as I recall, where, res judicata has been open. I think that, I would tend to think that a finding of no violation here based on what we have would preclude subsequent filings on those same particular issues. But if other material were found, even if it involved the same parties,
Right.
then that could be brought back.
It's kind of like the,
Yeah.
I'm sure Mr. O'Brien will argue, double jeopardy. It's kind of,
Yeah.
we're quasi-criminal, you just can't be tried over and over again for the same offense. If you can't prove it, you can't prove it, it's over and done.
That's my sort of rationale.
Any more questions on the motion, comment?
Well, I guess what troubles me, Mr. Hicks is alleging that if we would remand this to a full hearing and give him the opportunity for discovery, that he might be able to have and establish proper cause that a violation occurred. If we just summarily dismiss this case, then that's forever taken from him.
Well, Mr. Hicks has also said that the underlying facts also have to do with other related cases and filings involving some of the same actors. So the fact that this would just go away forever, I don't know if that really, that's full, it really carries full measure here.
That's one of my concerns, that if you either find a violation or dismiss it, that you're not gonna be able to bring these same issues forth in other cases that may be connected.
Collateral's possibility. Yeah, typically it would be the same case with the same parties with the same issue. I don't know whether the parties wanna, I don't know if we wanna, get it, I don't know.
Any more comment before we vote on the motion? I'm going to have Commissioner Kane restate the motion.
Oh, it was just a motion to follow the executive director's recommendation and find no violation.
And I'll just throw my 2 cents into the ring. It seems to me that we are not here as a panel to open up a fishing expedition. It is the complainant's responsibility to come before us, prove their allegations with personal knowledge, and I second the motion because I don't think that was done in this particular case.
Any other comments?
I guess, again, I would just reiterate that I think I'm not concerned about any additional people that might be brought into this. We're here on this instant case. And frankly, I don't know how we get to the facts unless we remand it to a full hearing. And then the facts might or might not support Mr. Hicks, but we won't know until that time.
We have a motion and a second. Catherine, do you have any opinion on your motion still?
No.
Sounds like we need to have a vote then.
Okay.
I I would do it
I
by
take a
roll
roll
call.
call vote.
Yep.
Yes, please.
Ms. Kaufman?
No.
Mr. Bromer?
No.
Ms. Tavares?
No.
Mr. Norman?
Yes.
Ms. Cunningham?
Yes,
Mr. Beatty?
Yes.
That motion is tied 3-3. In order for the commission to take an action, it requires 4 votes.
I'm not sure where we're headed. It seems as if the no votes would be one of moving this matter to have a full hearing.
right. I
Right.
think that would be the next motion.
Well, I'm not an attorney, so please bear with me. I move that we set this matter before full hearing before the commission.
Second. Okay, all in favor, please signify by roll call.
You want a roll call again?
Okay, all right.
Give me a second to lay out mine. Mr. Brown?
Yes.
Mr. Norman?
I'm gonna vote yes.
Ms. Cunningham?
Yes,
Ms. Tavares?
Yes.
Ms. Kaufman?
Yes.
Vice Chair Beatty?
Yes.
That motion passes 6-0. Motion will be set for that day, hearing that. The matter will be set for hearing at a date to be determined by commission staff.
Okay.
May I ask a question? I understand you did not hear, rule, or decide on the motion to dismiss, that it was just a preliminary review making the determination whether to set it for a hearing, and that the motion to dismiss would be heard later?
Well,
At least that's what I
I mean,
understood
we
Mr.
can-
Beatty just said.
that's true. I mean, I think it's kind of, I guess the
Well,
motion is somewhat moot, but if
you're getting
it's
Mike.
for formality,
I'm waiting till we're done
we can
discussing.
vote on it, we'd be happy to vote on it.
Well, at least
Go ahead.
following up, and the reason for the question was Ms. Cunningham's inquiry about whether to consider things outside of the complaint and the other information. Because quite clearly the affidavit from Mr. Seacard is unrebutted, and that was attached to the motion to dismiss. Or supplement, I should say, to the motion to dismiss.
Yeah.
And at least, I'm satisfied
So
that
are-
you hear the motion at a later date, but I guess I'm just trying to clarify that.
which only goes to the issue of employment, right? Doesn't go to the issue of the other questions.
Correct. And the in-kind contribution from ORP to the Schmidt campaign.
Well, there was no.
And at least, well, secondly, it did go to the other issue because it included the filings that would suggest that anytime you contract with a corporation, if you don't pay them up front for services, that you're taking an illegal contribution, that quite clearly isn't the case. So at least, I'm just trying to clarify things, I'm not
Right.
trying to.
No, I understand. No, I understand. I believe that, I understand your point. I believe that you may keep jumping here, whatever, just help me over here. I believe that, as you presented it now, that you might have to file a more limited motion to dismiss on those particular points that relate to the affidavit that falls outside.
So at least if I understand you're deferring going on the motion to dismiss until the subsequently set hearing.
Well, I think at this stage, we've set it for a hearing, so I don't think you can have a ruling to dismiss because discovery has to take place. And so there'd be a hold or a stay on any type of ruling until the discovery's been completed.
Or convert to summary judgment.
Correct.
Correct. We had that discussion last time, and I think we have the authority to rule on summary judgment, despite Mr. Klinger's objection.
All right, so no
Okay.
decision at this time.
Okay, well, thank you.
Thank you.
Thank you.
Thanks for bringing